He was a judge of the Bombay High Court. And those who have been connected with us know that the earlier insights given by Justice M.L. Tahaliyani have been well received. And this catalyzed us to make a request to him so as he could share a knowledge on a subject that is dying declaration, which is a relevant facet while we discuss Indian Evidence Act. And Justice Tahaliyani, those who have been connected from Maharashtra know it very well. And rather his judgments on Mumbai attack, that is Ajmal Kasab, and regarding the Adarsh Housing Society were not only covered by the state social media, but pan-India and pan-world. And the judgments were rather confirmed by the Honorable Supreme Court in the Ajmal Kasab, and nobody needs as such what is that judgment of Ajmal Kasab to be understood. The fact that the judgment has been upheld is a testimony of the fact that as what authority one has. It is just like a lawyer who feels happy when he succeeds the case. I would say the judge also has the same satisfaction to the effect once his judgment is upheld. That is one of the facets which we will discuss at the end of the webinar, not with this particular aspect, but what is the feeling and what one undergoes, because everybody wants that whatever knowledge he is trying to share or whatever knowledge he's penning is getting the stamp. Like for a lawyer, it is always the judge, and for the judge, it is the appellate authority, or in the High Court, it's the Supreme Court. But be that as it may, one does not require any certificate for the knowledge, because the knowledge, we all say, is just like a bottle of perfume. The moment you open, everybody knows and you cannot control it. And same way, when one speaks, one comes to know what volume of knowledge one has. Without taking much time, since the topic is quite interesting and fascinating for the students of law and lawyers as well as judicial officers. That is the dying declaration. What are the flips? What are the ways out? And what are the effects of that? We will request Justice M.L. Tahaliyani, who has been kind enough to accede to our request, to give his insights. Thank you, sir, once again for joining us, because your knowledge sharing is immensely not only good for the persons who are connected with us on the Facebook, as well as this group, and thereafter on the YouTube. So the knowledge being shared will continue. It becomes a treasure since it's on the YouTube, etc. And thereafter in different WhatsApp groups, it's circulated. So it keeps on disseminating what is just like the dominoes effect. So we are thankful to you for accepting and acceding to our request. Over to you, sir.
Thank you, Vikas. Thank you, Vikas.
Thank you, sir. Thank you
for inviting me for this webinar. And today's subject is quite interesting. Interesting in the sense that we are discussing with regard to the statement of person who is not available, who is dead. The statement recorded by somebody else is made admissible in evidence in the court of law. Therefore, the subject becomes little different from other subjects, because normally any statement made by the person outside the court is considered as the statement recorded during the course of investigation or previous statement, and that statement is not admissible in the court. It can be used for some other purposes, for contradictions and omissions. And the statement recorded by the person, by police or by the judicial magistrate under section 164 has to be tested in the court by examining the person whose statement has been recorded. But in the case of dying declaration under section 32(1), we are discussing with regard to a statement of a person who is not available, and statement is recorded by somebody else whose recording is not admissible in the evidence. Otherwise, had the person been alive, the statement would have become a statement recorded by police under section 161, or the statement recorded by the magistrate under section 164 of the CRPC. But for his death, the statement becomes admissible under Section 32 of Indian Evidence Act. Friends, this Section 32(1) of Indian Evidence Act is a provision of necessity, because, and this is mainly pressed into service independently or along with other evidence available with the prosecution. This is a provision of necessity because there might be cases when there is no other evidence and the only evidence available is the statement of the deceased. Now, there are reasons why such statements are made admissible. Normally, it is presumed that a person who is about to die, he is induced by the fact that he should not speak lie. Normally, the situation is so solemn and awful that he is not tempted to speak anything lie. Still, you see, therefore, this being a presumption, still the statement of deceased is always under scrutiny, and reliability is always a question, though the evidence is admissible, but reliability of that statement is always a question. Unless the statement which is admissible under Section 32(1) of Evidence Act, it is found reliable, it cannot be pressed into service for the purpose of conviction of the accused. So there are four things which we need to discuss in this meeting today. First is the admissibility, second is reliability, third is proximity, and fourth is, I think I have noted down, I'll let you know. Fourth is whether the person was in expectation of death when he made the statement. These four things are important to be discussed in this meeting. So first thing we'll take is the admissibility. Now, it is beyond question that the statement of the deceased whose cause of death has come into question in a case. Now, statement of deceased is admissible in the case when the cause of death of that person is in question in that case. Otherwise, it is not admissible in any other case that the statement was recorded. Now, when the cause of death of the person whose state, this is very important, cause of death of the person who is dead, when his cause of death is in question, then the statement made by such person before his death is admissible in evidence. The statement regarding cause of his death or the statement regarding circumstances which resulted into his death. Now, this is in two parts. One is cause of death and one is circumstances which resulted into his death. Now, there may be a statement regarding direct cause of death. There may be a statement regarding circumstances which resulted into death of deceased. So this section is in two parts. Now let us assume that the deceased gave a statement that when I was going to school of my child, somebody, you see, who was making accusations against me, I questioned him. So he suddenly poured some combustible or thing on me, or petrol or kerosene, and he set me on fire. Now, the statement of that lady that she was set on fire by X is a statement regarding cause of death. So this is admissible in evidence. Now, after some time, it was realized by the police that the name of the person was not correctly stated by the deceased while giving the further statement was recorded. Now, during the course of further statements, she clarifies that she knew him by so and so, but actually his name is so and so, but he was popularly known as so and so. So these are the circumstances which can be considered in the further statement of the lady. So this is in two parts. So this can be divided in two parts. One is cause of death and other is the circumstances involving death of the deceased. Such a statement is admissible in evidence. Now there is no doubt about it because it has statutory provision. and this being statutory provision in Evidence Act, it is admissible and it need to be admitted. Now, this is admissible. Now, the question when admissibility of dying declaration is considered, the question always arises whether the dying declaration needed corroboration, whether a dying declaration of a person needs to be corroborated, whether uncorroborated dying declaration can be a basis for conviction. Now, the law is settled on the point that dying declaration, the statement under section 32(1) of the Indian Evidence Act made by the deceased, is an independent piece of evidence which can be accepted without there being any corroboration to that statement. Now, corroboration cannot be insisted. If the corroboration is available, good. If the statement itself is doubtful, then where is the question of corroboration? Because you cannot corroborate the unreliable fact. The fact which is independently admissible in evidence has to be reliable. If the dying declaration is reliable, there is no question of dying declaration being corroborated. If corroboration is available in the form of eyewitnesses, no issue, because eyewitnesses evidence is again an independent witness evidence. Therefore, the admissibility of dying declaration is always there without there being any corroboration. Dying declaration don't need any corroboration as a matter of rule. There is no rule of prudence, there is no rule of law which requires corroboration. Even no court has said the rule of prudence requires that the court should search for corroboration. It is clear-cut law that it is independent evidence and it can be taken into consideration without there being any corroboration. Now, whether a particular dying declaration needed corroboration or not, to my mind, there may be judgments otherwise, I don't know. But to my mind, this question is not to be considered, because this being an independent evidence, you cannot categorize it. That particular dying declaration needed corroboration and other dying declaration did not need corroboration. If the particular dying declaration is found to be unreliable, the question of corroboration doesn't arise. You cannot corroborate the fact which is questionable, which is unreliable, which is doubtful. Therefore, the dying declaration is an independent evidence and doesn't need any corroboration. If it is available, well and good. If it is not available, no issue. The question will be reliability only. Now, after admissibility of dying declaration, now let us go to the reliability of the dying declaration. Now, reliability of as reliability of each and every piece of evidence is required to be examined by the judge, it goes without saying that the reliability of dying declaration also will have to be examined when it is produced as a piece of evidence. Now, which dying declaration is reliable, how it is reliable, why it is not reliable, why it should be rejected, all these questions are questions of facts. And court trying the case will have to decide and will have to give finding whether a dying declaration is reliable or not reliable. Now, it depends upon facts of each case. There may be circumstances which may create doubt about the credibility of the dying declaration. Though it is normally accepted that the person who is in expectation of death will not tell lies, but there are no exception to that. There are persons who are dying, but they give false evidence, false declaration, which becomes dying declaration only with a view that this man has already troubled me a lot. Let us take a case of husband. Wife commits suicide because of, you see, torture by the husband. She commits a suicide. Now, there is possibility that a wife may feel she was tortured so much that now this is the occasion that she should take revenge from her husband. Therefore, the trial court has to examine whether this is really reliable or not. There may be cases where the deceased may lie. Deceased may lie on her own. Deceased may lie on the inducement made by her relatives. It is possible that by the time the dying declaration is recorded, father and mother reached there, parents reached there, brothers reached there. They may tell her, they may ask her, they will tell her, now it has happened, abhi inko chhodna nahi hai. This may happen. So the judge has to be very, very cautious while examining, while evaluating the evidence of the deceased person. So the reliability is always a question. Now, reliability, then there are so many judgments in which the findings are given that this is not reliable because this is recorded by the police. This is not reliable because this is oral dying dictation. This is not reduced into writing. It was not reduced into particular pro forma. It was not reduced into question and answer form. It was not reduced in the language of the deceased. There are so many issues. But ultimately, the question will be whether it is reliable or not. These are all, there is no pro forma. There is no law that oral dying declaration cannot be accepted. It needs to be dying declaration. You see, most of the dying declarations are oral dying declarations, reduced into writing. Some people have a misconception that the dying declaration which is reduced into writing is a dying declaration, written dying declaration. It's not so. The dying declaration, written dying declaration, to my mind, is the dying declaration which is written by the deceased herself, what we call as a suicide note or death note. Followed. So the dying declaration given by the deceased, reduced into writing by somebody else, to my mind, is oral dying declaration. So the evidentiary value of oral dying declaration and declaration in writing is not, you see, cannot be categorized. You cannot say that dying declaration which is oral and reduced into writing is more reliable, or dying declaration which is reduced into writing and not oral, not only oral dying declaration given in the court by the witness is more reliable. There cannot be two categories, because the circumstances at that time when the person is dying, there are circumstances which at times do not permit the relatives, do not permit the police to record the dying declaration. While the deceased is being taken to the hospital by neighbors after the incident, and she tells her neighbors, my husband poured kerosene on me and he set me on fire. Deceased is lying on the road and he is being taken to the hospital by the persons who reached on the spot later on, who did not witness the incident. He tells those persons, the X person came and he fired shots at me, and because of that I have been injured. Now, by the time the deceased is taken to hospital, he is no more. He is declared by doctor to be dead before admission. Now, in these circumstances, the question will arise whether the declaration made by the deceased to a person who was taking him to hospital is less reliable as compared to the statements recorded by the magistrate in the presence of medical officer. I don't think that we can give definite finding on that. There are cases where the dying declarations recorded by the magistrate in the presence of medical officer are found to be not reliable as compared to the statement given to the person who was taking the deceased to the hospital. Now, the person who was taking the deceased to the hospital is an independent person. He doesn't know the deceased. He doesn't know the assailant. He has no acquaintance. He has no enmity, or he has no relations between either the deceased or the assailant. Now, in these circumstances, the question will arise whether this statement of such person regarding dying declaration given to him, oral dying declaration given to him by the deceased, can be accepted or not. It is, according to me, a very good piece of evidence, because there are no reasons, there are no circumstances to make it dubious or doubtful or questionable. Sorry, just a minute. So we have spoken about the oral and dying declaration in writing. There are these two types of dying declaration are there, but some people hold a view that dying declaration which is reduced to writing, orally given by the deceased, is a dying declaration in writing. I respectfully don't subscribe to that view. My view is that the dying declaration which is reduced to writing and given orally is oral dying declaration. Now that is not very important question to be discussed, whether you consider it this way or that way. Ultimately, the question will be of the reliability, whether you call it as an oral dying declaration or dying declaration in writing. The question will be of the reliability of admissibility. There is no question. The question always will be of reliability. So reliability, when the reliability of dying declaration comes into question, it comes into question many a times if it is recorded by the police officer. Now the plea is taken by the defense that the dying declaration is recorded by the police officer. Therefore, it is questionable. It was statement under section 161 of CRPC. If the person survives, then you can say it is 161. Otherwise, there is no question of that statement being under section 161 of CRPC. Whether the statement is now, sometimes in government hospitals, big government hospitals, there is always a police constable on duty to record medical legal cases. Now, it may happen that when the patient deceased, who was in injured condition, arrives in the hospital, he was taken to the constable or officer who is on duty for medical legal cases. Now, in his register, he records such and such person with injury on abdomen or chest brought to the hospital by so and so, and he gave the history that he was assaulted by XYZ person at so and so place by means of a knife, and he inflicted multiple injuries on him. Now, this is recorded. After recording this entry in the diary, the deceased is taken to the casualty officer, or by the time casualty officer reaches him and he starts examining him. But before the casualty officer examines him and starts his treatment, the person is dead. Now, there is no occasion for the police of the concerned police station to come on the spot. They were not even intimated, because he was directly brought from the hospital to the from the spot to the hospital. There was no occasion for the doctor to treat him. There was no occasion for doctor to give him medical certificate. Now, at the statement, now tell me whether the doctor will write a medical certificate that he is in fit condition to give a statement, or he will treat him. He will first give him treatment. So in these circumstances, if the question is raised that there is no medical certificate, that question is to be, that argument has to be discarded. Now it's a matter of common sense that at that time the medical officer's priority would be and should be to treat the patient and not to write a medical certificate that he is in fit state of mind to give a statement, and he is speaking coherently and all these things. Therefore, there are so many ways of, so many places where the statement of deceased might be recorded during the course of, between the time of incident till his treatment starts. So there are so many occasions when he may speak and it may be a dying declaration. And ultimately, The question before the court will be whether he was in fit state of mind to give a statement which can be admitted in evidence. Now, whether he was in fit state of mind necessarily doesn't require a medical certificate. If we insist upon this, then it will be difficult. In a case I told you just now, how will you say? If the police officer is there, medical officer is there, and he gives evidence in the court later on that he gave such a statement before me, that is sufficient. That is a certificate given by the magistrate, medical officer. So even if the medical officer suppose doesn't reach, what can you do? The question will be whether that police officer and officer who made the entry, whether they should be believed or not. Therefore, there is no rule of law that the statement recorded by the police cannot be treated as dying declaration and has to be rejected. Second, now arguments are, advanced, that the police officer reached on the spot, he recorded statement of the deceased, treated his FIR as under one section 54 of CRPC, and he started investigation, went to the spot, did Panchanama and all these things, and he completed the investigation and filed charge sheet. In such cases, a question is always raised whether the statement recorded by the investigating officer can be reliable statement or not. Now, why this argument is advanced? Because the argument is that the officer who is investigating the case himself is interested in positive result of the case, is interested in getting conviction for the accused, and therefore he must have recorded the statement suitable to the prosecution. This argument has to be rejected on two grounds. One, that when the police officer reaches the spot and he records the statement, he is not sure that he himself will be investigating the case, because he received a phone call on mobile police van or at the police station for 100 number of police, and he reached the spot. He recorded the statement. He never knew that ultimately the senior officer will give the evidence case for investigation to him only. And even if he knew that he is the only officer in the police station, others are police state constables, it cannot be rejected because he has to investigate the case. There is no presumption against the police that the officer who is investigating the case is always interested in conviction. There is no such presumption. How can you say like this? So ultimately his evidence in the court after cross-examination, whether it, after tasting it, it is for the court to decide whether his evidence is to be accepted or not. Only because a particular label, he is a police officer, he is an investigating officer, he is not judicial magistrate, he is only executive magistrate, or he is not Tahsildar, he is Nayab Tahsildar. Tahsildar was available, but Nayab Tahsildar was intentionally called because he was favorable to the complainant. Now the question will be whether he was favorable to the complainant will have to be decided on the facts of the case. And even if he is friend of the complainant, his father of the deceased, let us say, what is wrong there? What father of the deceased will do in these circumstances? He would call Nayab Tahsildar because he knew him. कि सर ऐसा हो गया, अभी इनका स्टेटमेंट लेना है, आप आइए या किसी को भेजिए. Followed me? So there is no, you cannot label any person that statement recorded by this person cannot be admitted in, is not reliable. This always, as stated repeatedly, is a matter of fact, and it has to be examined by the court during the course of trial. Now, sometimes a statement is made to the relative, father, mother, brother, who reach the hospital immediately before the police comes or before the executive magistrate comes. Again, the question will be whether such evidence can be rejected. No, such evidence cannot be rejected only because his brother or father or mother. There has to be grounds to reject the evidence. There are unless circumstances which create doubt, which makes the evidence of mother or father questionable. We cannot reject the evidence of mother or father only because they are mother or father or any other relative of the deceased. So, briefly stated, the acceptance or rejection of statement made by the deceased whose cause of death is in question in the case cannot be rejected only because it is orally made to so and so person, not made to so and so person, or it is not written by the executive magistrate. There may be cases when executive magistrate is not available. Doctor was available, but his certificate was not taken. When the executive magistrate came and he started recording statement, the doctor was not available. Before that, doctor was available, but by the time magistrate starts writing, another emergency case comes and doctor is told that the person is in a very precarious condition. Now tell me, in these circumstances, what a doctor would do? He would attend the precarious case instead of writing a certificate. He would rush, he would say, paper udhar leke aao, main karta hu, main likh dunga, main baad mein likh dunga. So circumstances are to be examined whether any doubt is created, any serious doubt is created. Doubt, just because you feel it is a doubt, cannot be a doubt. It must give rise in your mind that because of this reason, there is possibility of manipulation. There is possibility of deceased not telling what is actually recorded. There is possibility of executive magistrate recording at the instance of somebody else. There is possibility of medical officer giving evidence with regard to fit state of mind at the instance of relatives because they are known to him, or because of some extraneous reasons. Unless these things are brought on record, there is no straight jacket formula of recording dying declaration. There is no format. Question and answer is preferable, but there is no rule. Executive magistrate is preferable, but there is no rule of law. Now, after this, the question will come, when there are multiple dying declarations, what a judge will do. One dying declaration recorded on the oral dying declaration given to the persons who gathered on the spot. Another dying declaration given to a person who brought the deceased, male or female, whoever he may be, to the hospital. Third dying declaration given to the police officer on duty. Fourth dying declaration given to the police officer who came from the police station. And fifth dying declaration given to the executive magistrate who was called by the police officers. Now there are multiple dying declarations, but if they are consistent, there is no major discrepancy in any of the dying declarations. There is no reason to discard the evidence because multiple statements are recorded only to support the prosecution. There is no such rule of law. It is possible, and it is not possible, but it always happens that you find a five dying declaration, you cannot find all the five dying declarations to be in the same language or in the same format or in the same sequence. The sequence may be different. It is possible. It is possible that the executive magistrate was brought to cement the case, to make it more strong. Now, whether in such circumstances the judge will reject the evidence of earlier four evidence witnesses only because there is evidence to show that the executive magistrate was brought when the lady or the person who died was not in fit state of mind. This is a very typical case. These cases are very difficult for the judges to decide, because the executive magistrate, it is now, judge is sure that executive magistrate's evidence is not to be relied upon. Now, in this circumstance, whether he can reject other evidence, the evidence of other witnesses who have heard the deceased saying particular thing, oral identification given to them, whether he will discard the evidence of police officer who recorded his statement in the hospital before the arrival of the executive magistrate. No. Again, the question will be one by one, he will have to examine it. But if there are serious doubts about each and every statement, then the safer course open to the judge is to give the judgment of acquittal or benefit of doubt. He should not stretch the case beyond a particular limit to find out the material for conviction. If there is a lurking doubt in my mind that no, it is unsafe, it is possible that it might have happened. The question might, you see, when it comes might, then the judge has to take the safest way, because convicting a wrong person is a serious thing. You cannot give him back his 14 years and whatever years he has to spend in jail. You cannot give him back. So it is very, very delicate piece of evidence which requires very delicate examination, and particularly because there is no necessity of corroboration. Since it is independent piece of evidence, the person whose statement we are admitting in evidence is not available for cross-examination. You see, very delicate situation is created under section 32(1). Therefore, the judge has to be very, very careful in deciding the cases on the basis of which are based on identification. When you record statement of the person in open court and he gives evidence, he is available for cross-examination. You can test whether he is lying or what. But the deceased is not available. He gave the statement within fraction of minutes and died. So you have such piece of evidence which might not be recorded on good paper, which might be recorded on torn small paper. Pen may not be good, language may not be good. There are so many issues. And therefore, I say it's a very delicate piece of evidence and requires a very closer scrutiny, doesn't require any corroboration, and therefore more delicate. So the discussion so far is that the dying declaration is admissible. It is independent piece of evidence, doesn't require any corroboration. Reliability is always a question, and the judge has to see whether it is reliable or not. There cannot be any straitjacket formula to say that this is reliable, this is not reliable. There is no rule of law, statutory or otherwise, rule of prudence that the statement shall be recorded in this manner only, or recorded by so and so person only. This is what we have discussed so far. Now the question comes about the expectation of death. This statement is given when the person is in expectation of death, then it becomes a dying declaration. Now, expectation of death. Now, he will die immediately or after some time, we don't know. He may survive for 2 days also. Today, a statement is recorded and the person survived for 3 days. He died after 3 days. So you cannot continue to record his statement daily. The statement which is recorded. Now, if he died after 5 days, or 4 days, it hardly makes any difference. If the manipulation is required to be done, then it could have been done after 5 days also. So the manipulation part is to be examined not on the basis of, manipulation is not recorded on the basis of the days between the recording of statement and the death. Thereafter, the question of proximity comes. The time of death, proximity of the circumstances in which the person died. Now the proximity comes. Now whether it is proximate or not, it is again a question of fact. You cannot lay down a particular timeline. If this is proximate, this is not proximate. So we have discussed admissibility, reliability, then the format, who can record the statement, who. I told you that anybody can record the statement, anybody can give evidence with regard to the oral dying declaration of the deceased. Reliability is always a question. Expectation of death, proximity. Now thereafter, I think most of the issues pertaining to the statement of the deceased involving the cause of death or the circumstances which resulted into death of the deceased, which we call dying declaration, are covered, because there are so many case laws. You can go on citing case laws after case laws. They are repeated, and repeated views are expressed by the Honorable Supreme Court and the High Courts on this subject. There was one judgment in between of the Honorable Apex Court, in which it was stated that unless the medical certificate is there, the dying declaration cannot be recorded. But ultimately, that judgment was again examined, and now the present legal position is that the medical certificate is not, it cannot be insisted upon. It depends upon the facts and circumstances of the case, whether in particular facts medical certificate could have been obtained. If it could have been obtained and was not obtained, then it becomes a question of fact to be examined why it was not obtained. If there is a satisfactory explanation for not obtaining medical certificate, the court may consider it. But that judgment, after that judgment, which was there for a few years in force, a lot of acquittals had taken place, but thereafter, again, I think that judgment was, after that judgment, there were a few more judgments which actually put down the law that the medical certificate is not a matter of rule. And as I explained to you, and everybody will realize that medical certificate in each and every case is not possible. Executive magistrate in each and every case is not possible. Police officer of a particular rank and in each and every case is not possible to be sought immediately. If it is 2 o'clock in the night, you will have to go to the executive magistrate. You will have to wake him up. You will get ready. And if the person has injuries to a large extent, the person may die before the executive magistrate comes. You cannot wait. Somebody has to record who is on the spot. Even nurse may record it. Even nurse may record his statement or her statement. So these are the factual conditions. These are the matter of facts. We cannot lay down any straitjacket formula for that. So these are my views, friends, on the subject dying declaration. And if anybody has got any questions on that, we can discuss it and we can proceed further in the matter, because it is possible that few of the things which some of the participants might be expecting, I might not have said, or I might have said something which according to them is not correct, they are always welcome to tell me, and that can be discussed. There is no issue about it. It is possible that something which I expressed as my view may not be acceptable to somebody, or he may have some other view on the basis of some judgment. That also can be discussed. There is no issue about it. Welcome. Question and answer. Vikas?
Thank you, sir. It only shows your humility that as we say that the more higher you rise, the more humble one becomes. That is the hallmark. So this, the name is not there, and quite you have covered that aspect. It says Apex Court has said dying declaration is not necessarily a declaration of the deceased to a convict accused. At times, to take revenge, victim may give a wrong statement. What is your view?
I said already that victim may give wrong evidence, victim may give wrong statement on her own, on his own, or at the instance of somebody else. Dying declaration is admissible in evidence. I told you that dying declaration, whoever is the participant, I wanted to tell him that I told that dying declaration is admissible in law. Whether it is reliable or not, it is to be tested. Now, in this case, if false statement is given, then dying declaration is admissible piece of evidence. Now, any piece of evidence which is admissible in law, whether it is reliable or not, it is to be examined like any other piece of evidence. Even oral evidence, even the eyewitness evidence is to be examined whether he is reliable, fully reliable, partly reliable, not reliable. So similarly, the evidence of deceased is, the statement of deceased is also to be examined. And if in cases it is possible, that court may give finding that mother came and she influenced her. Otherwise, she was reluctant to give evidence. She did not say anything to the person who brought her to the hospital. And there may be other circumstances. The person who is accused of, killing the deceased may bring some other circumstances to show that she is tutored. If she is tutored and on the basis of that tutoring she gives evidence, that is to be rejected. Therefore, I don't think that Apex Court has said it is a matter of law. It has to be examined. In that case, it could be. I think this must satisfy his question.
Yes, sir. Yes. I remember I had handled a case while opposing a bail. In that particular case, the paramour and the wife had burnt her, but while she was admitted, the dying declaration was changed to the fact that they said that you are being admitted. The father was also quite tensed, and then they said that whatever statement I had initially recorded was wrong. In fact, they are all innocent. So, as you rightly said, you have to work with a caveat also. Sometimes the police also plays a mischief.
Yeah. Police, you see, the trial itself is, the examining the correctness of the evidence, whether it is police or independent witness or the top-ranking police officer. Now, in few cases, top-ranking police officer records statements which are admissible in evidence, like statement recorded by the confessions recorded by the magistrate. Now, confessions recorded and under some laws by the officers of the rank of DCP and above are that they are admissible in evidence. But whether they are reliable or not, that is to be examined by the court. Admissibility and reliability, these are two different things. Admissibility, you cannot reject. No, I will not record, because it is admissible, you record it. Now, whether it is correct or not, you give finding at the time of giving judgment.
This is, can a dying declaration become a sole ground for conviction? This
Yes.
is by Radhesham Maurya.
Yes, if it is reliable, it can become sole ground. It doesn't require any corroboration. Only reliability is the question.
Even otherwise, on that analogy, that it is the quality of the evidence rather than quantity of the evidence.
Yes.
This is by Ishwar Prasad. What happens that the person was dead, but his dying declaration, he has written decoration. I think he wanted to write a declaration, is prepared.
Achha, it is prepared later on. There are cases where the person is dead, dying declaration is prepared later on, and it is produced as a dying declaration. A wrong time is mentioned. Time of the declaration is before death of the deceased, recorded in the hospital, and it is manufactured. So if it is manufactured, Whether it is manufactured or it is a correct dying declaration, as I told you, it depends upon the facts of each case. The judge has to examine it. It's a matter of fact. Judge has to give finding whether it is appears to be a manufactured document. There may be circumstances to show. There may be other witnesses, nurses or something. You can examine the defense witness that nobody was there and he did not say anything when he died. And where from this paper came. If it is manufactured, it can be demonstrated by evidence, by cross-examination, by statement under section 313, by a statement of the defense witnesses, depending upon the case. Manufactured statement cannot be accepted as a dying declaration. It has to be rejected.
Even as a judge, one has to see that the way we say that one has to sieve the wheat from the chaff.
Yeah.
This is by, I'm just saying, get posted on the Facebook. This is by Umesh Gandhi. Suppose a person gives a dying declaration that he was stabbed by X and then dies after 3 days due to reaction of a medicine. Would does that dying declaration has any relevancy?
Please, can you repeat it?
So, suppose a person gives a dying declaration that he was stabbed by X. However, he dies after 3 days due to reaction of a medicine or some other reason. Is that dying declaration of any relevancy?
Now you see, in this question, the cause of death will come in question. The person who stabbed him, he is accused of 302 PC. He is facing the trial. The person who is stabbed, he died after 3 days, maybe due to the reaction of medicines or due to septicemia. Now, if he dies due to septicemia, which is we call so the whole body, you see, has become infected and the person is very difficult for him to survive. If he dies septicemia and septicemia is the cause of the stab injuries, then the dying declaration will be taken into consideration, because it is because of stabbing that he suffered septicemia. It is because of stabbing that he lost blood and shock. That we read postmortem reports that died due to shock, trauma, hemorrhage and shock. Now shock is when you lose a lot of blood, then they call died due to shock. Now the ultimate question is that why it happened? It happened because of the stabbing. Now if there is a concrete evidence that he would have survived but for reaction of the medicines, wrong medicines were given, then that will be a different case. If there is evidence to show that he was recovering and he was in good condition, and it at the most could have been a case of attempt to murder under section 307 if the stabbing is proved, but because of wrong medicines which resulted into reaction, doctor was negligent, he did not attend the patient in time, then it is possible to prove that death was not due to the stabbing, but it was due to the reaction of the medicines. Otherwise, he could have survived. Then in that case also, the person may not be acquitted if the stabbing is proved and intention to cause death or intention to cause such bodily injury which is sufficient to cause death is proved, then in that case he may be convicted for 307 of IPC, or maybe even 326 of IPC or 325 of IPC, depending upon the weapon and injuries in the case. But it should be concretely brought on record that he died of reaction of the medicine and not septicemia, because septicemia is not reaction of the medicine.
This is by Raj. Is a dying declaration recorded in an audio or a video on a mobile phone admissible or is admissible? That is the question.
Yeah, it is admissible. If oral dying declaration is admissible made to somebody else, why audio video is not admissible?
This is by Zulfikar Munshi. What is the difference between last available statement of the deceased and dying declaration?
Last
available statement of the deceased and a dying declaration. What is the subtle difference between the two?
No, this is a case of multiple dying declarations. You see, dying declaration word you don't find in Evidence Act. Dying declaration word is not an Evidence Act. In section 32, there is no word like dying declaration. Section 32 says the statement made by the deceased involving cause of his death or the circumstances which resulted into his death. Therefore, any statement made after the injuries were suffered till he died are all dying declarations. Now, they are all, we can call it multiple. We cannot say this is dying declaration and this is the last statement of the deceased available. The last statement of the deceased is also dying declaration, and the first statement recorded in the hospital immediately after arrival is also dying declaration. So this is a case of multiple dying declarations. Now, whether the multiple dying declarations are reliable or not, again, will be questioned in that particular case. So you cannot say that this is last statement. Dying declaration is the statement of the deceased. We call it as a dying declaration. So first statement is also statement of the deceased. Last statement is also statement of the deceased. So I cannot say this is dying declaration and this is not dying declaration. This is both are dying declarations. There are multiple dying declarations. Which to rely, whether to rely or not, that is the headache of the judge. He will examine it.
This is by Radhesham Maurya. Victim comes himself in a police station and files the FIR and dies subsequently. Will it be regarded as a dying declaration, suicide note, or not?
Victim himself comes to police station and gives
and dies after recording the statement. He says whether it will be regarded as a dying declaration.
Yeah, it is statement recorded by the statement of the deceased involving cause of his death.
Yes.
Forget about the word dying declaration. This is statement of the deceased given to the police regarding cause of his death. So if they will record suicide, ADR, accidental death case, and investigate whether it is suicide or not. It is possible that somebody else might have stabbed him, and he might have given wrong. There are no, you see, there are such incidents also, rare, but.
So this is by Nagendra Kumar. A gives dying declaration to his father, whose statement is recorded under section 161. But father is dead before the trial starts.
Okay. So the person before whom dying declaration was given is not available.
Yes.
Then what can you do? You can't do anything.
Here's Mrinalini Deshmukh, probably you know, she's one of the leading lawyers out in Bombay. She has posted on the Facebook, though it's a question different. She says, your views on the position of trial by media, especially once you have covered a lot of cases where they were widely covered on media.
Who is she?
So Mrinalini Deshmukh, she had sent me a message that she had argued the matter of, she had represented Rajesh Khanna when there was a difference between Rajesh Khanna, Vikal Khanna and Akshay Kumar. She said that she had appeared before you.
Under protection of women.
Domestic violence. DV Act. DV Act.
Domestic violence.
Yes. She said that she had appeared before you. She said that since you have done a lot of cases of the media trial, what is your view on the position of trial by the media?
Mr. This question was put to me last time also, and this question is put to me.
Because I've seen that you've done a lot of cases which had a lot of media glare during your tenure.
I told you, Mr. Vikas, that media hardly causes any effect on my mind, and I after the Kasab trial and even before that Gulshan Kumar trial also, it was since he was he belonged to the industry, Bollywood industry, so the lot of interest was there, and very renowned persons had come as witnesses, and Bollywood actors and actresses had also come as witnesses, though some of them were not examined. So I have seen that a lot of media, but I am always, you see, very clear in my mind. It doesn't, it should not affect us.
You should be unfazed.
We are hardly influenced by. Media should have some control, no doubt about it. But if they are not regulated by us, so we should regulate ourselves. There is no problem. We should regulate. And I have been regulating myself throughout my career as a judge. Nobody can say कि media in Kasab trial only media used to remain present daily because outsiders were not allowed. Even pen was not allowed, wristwatch was not allowed. Everybody was required to keep his wristwatch, pen, all material outside the prison, and the dot pen and letter pad and everything was given by the prison authorities daily to the media persons from Delhi. And next day they will get fresh. So the earlier day will not, the earlier day pen given to earlier day will not work. They will have to take fresh pen next day. So the media person used to remain there. They used to take note while the case was going on throughout the day. And when the last judgment was being pronounced, 3rd of May 2000, I think it was 2010. That was the day of judgment, not punishment, conviction or acquittal. So the court was full of media persons, maybe around more than 200, and there was no place to stand in the court. So it doesn't make any difference to me. I see the relevant portion of the judgment. I went on reading for about 3 hours, which appeared in the newspapers next day. I did not only read the operative part, I read the whole, the complete 1565 pages. First part of judgment was ready, and relevant pages were read out to them, and they reported it. So sometimes there is wrong reporting also because our language and their language, there is a difference, but we have to ignore it.
Yes, sir. So the last question we will be taking, video recorded in suicide, could it be taken as a dying declaration or not?
Video recorded
dying declaration could be in suicides could be taken as a dying declaration or not?
Why not? Video of the deceased, na?
Yes, sir.
You see, these are all new technology available to us. On the contrary, it is good. On the contrary, it is good. Earlier, there were no executive taluka places. There were few talukas in the district. Now you have a lot of talukas. Even small villages, you have Nayab Tahsildar, who is executive magistrate. He is available for recording. There were the days 20 years back or 15, 20 years back, 25 years back. Nayab Tahsildar was a big officer for the village when he used to come to the village. Ki Nayab Sahab aaye hain, Tahsildar Sahab aaye hain. SP was a big police officer. Aaj SP Sahab aaye hain, SP Sahab aaye hain. So you see, these things, when Nayab Tahsildar's statement could be admitted in evidence, video recording is, I think, a better piece of evidence. Only thing is that you have to prove that there is no manipulation, there is no interpolation of voice and all these things. These are always the reliability questions. There is no question of rejecting them not admissible.
Yes, sir. So we are just closing. I'm just telling the tomorrow's topic.
I think I have given answers to all the questions raised by them.
Yes, sir. It goes without saying. So tomorrow in the series of our webinars, tomorrow we will be having, as those who have been connected with us, part 1 on the motor accident claims we have already done. Tomorrow is motor accidents claim, nuances of negligence by Mr. S. Srinivas Raghavan, an advocate from Madurai bench. The earlier part 1, which he dealt with, is already being well received on the Facebook as well as on the YouTube. So do stay connected. But since the Madras physical courts have started, though it's a weekday, we will be having the webinar tomorrow at 5 p.m. So do stay connected with us to have the insights on the motor accident claims by Mr. S. Srinivas Raghavan. And sir, as usual, your session was crisp, to the point, and we could understand. And it is one of the facets, as I initially stated, that which a common man as a student of law and lawyers do want to understand. Though it looks on the first brush, it's only section 32, but it has its own facets and its own development with the flux of time, like you stated. Like these facets of video recording, audio recording are the tools which have emerged during the recent times. And these are the challenges, and the courts have come well with these challenges, and the law has developed according to that. And I'm just reminded before we part for the day, as they say, old order changeth, yielding place to new. So the processes of law also keep on changing. And what we say that everything is temporary except for change, which is permanent. Thank you, sir, for giving the insights. And thank you to all the participants who have been watching live on the Facebook, as well as those who have connected with us on this platform, and those who will ultimately watch us on the YouTube when the video is uploaded. Everyone stay safe, stay blessed. Namaskar, sir.